A digital world, our thoughts, our memories, keepsakes, all no longer stored in boxes or albums. They're online or in the cloud. It's convenient, sure, but what happens to them when we die?
Even when we go, our Facebook pages live on. Whether you think this digital immortality is cool or creepy, one thing is for sure. It's confusing the legal system, which has been slow to deal with so-called digital assets.
People don't have a shoebox full of photos anymore. Usually they have things that they've taken on their camera and then upload to the cloud. It could be things like your Facebook account, LinkedIn, Twitter.
Or email. Take the case of Justin Ellsworth, a Marine from Oakland County, killed by a roadside bomb in Fallujah in 2004. His parents had to take Yahoo to court to get access to their son's final words, his emails. Michigan is one of the first states to deal with this digital dilemma. It's called the Fiduciary Access to Digital Assets Act, FADA for short. It became law this summer.
It's supposed to identify who is entitled to access to different aspects of electronic digital assets.
Howard Collins is an attorney specializing in estate planning. He explains this new law allows you to identify who you want to control your digital assets, like social media accounts, cloud-stored photos, and emails. And you can also identify what you don't want them to see.
They may or may not want that content shared if they become incapacitated or when they die. And so this new law allows for those folks to say, I want to give everything, or I want to give some of my digital assets to be able to be utilized after I'm incapacitated or die, or I want them deleted.
I got a Facebook message from my sister the other day asking me to become her legacy contact, which means if something should happen to her, I control her Facebook account. Now, I was surprised for a couple of reasons. One, when we were kids, she didn't share anything with me. And two, if Facebook lets you pick a contact, then why do we need a law?
The potential downside with using an online tool is that under the Fiduciary Access to Digital Assets Act, there is primacy given to the online tool. So if you fill out an online tool form online, then you decide you're going to write a will and have a different person to manage your digital assets, the online tool is going to control.
And one other thing. If you have your spouse's, parents, or kids' passwords and figure you can deal with their digital assets on your own?
The law says you shouldn't. I mean, that's the simplest answer.
So I'm breaking the law by going into my wife's Facebook.
I would say the technical answer is yes. I'm not going to tell you that I know of anyone who had that enforced against them.
So what do you need to do to protect your digital assets? Well, the worst thing to do is nothing. Now, you may not be too concerned with all the data you leave behind, but your loved ones might be. And they're going to be in for a lengthy and expensive legal fight to get it back. So put it in your will. You can be very detailed about who gets access to your accounts and exactly what they should do with it when you're gone.